The final matter to come before us today is Mahoney versus Mahoney. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve any time for rebuttal, I'm keeping the clock this morning, so if you let me know when you get started, I'll let you know where you're at in terms of time. We have read the briefs and we're ready to see
Good morning, Your Honors. May it please the Court. My name is Brian Carr, and I represent the appellant.
And you're not related to him.
I am not related to
We'll make sure we say that since we go on YouTube.
but there's a good resemblance. No, we're not related. I represent the appellant, Dennis Mahoney. It's been probably about a dozen years since I've been before this court. It's a pleasure to be back. It's also a pleasure to let you know we don't have a final appealable order issue to argue to.
You never know, you never know.
That's true, you never do know. I'd like to reserve 5 minutes of my time, if I could, for rebuttal, please. Fairly straightforward argument that I'm here on today, Your Honors, and that is that the trial court erred in its decision regarding spousal support in this case. Although my argument is broken up into two different complaints. First, I believe that the lifetime or indefinite component of the spousal support was in error, as well as the amount of $550 per month. So I've got one assignment of error kind of broken into two. I don't believe there's any dispute that we're here on an abuse of discretion standard. I believe I met that standard because the spousal support order was arbitrary, unreasonable, and not equitable upon the facts. There's a couple of cases that I cited in the brief, the merit brief and the reply brief, where courts, when they are reviewing spousal support determinations, have opined that while the abuse of discretion standard does apply, it's not unbridled discretion. And I think that goes hand in hand with the fact that domestic relations is a court of equity. The analysis hasn't changed in quite some time. When we're looking at spousal support determinations, we look to Revised Code 3105.18, and there's a litany of factors that courts may but are not obligated to consider, from income, age, duration of marriage, assets in retirement, earning ability, standard of living, et cetera, et cetera. I think that list is not exhaustive, and courts are able to kind of go outside that list to see exactly what is equitable. The court in this case did order indefinite support in the amount of $550 a month. Looking at the indefinite nature, and what I'm referring to as lifetime.
I was just going to say, because they're making a point that it's indefinite, not lifetime. You refer to it as lifetime, they refer to it as indefinite.
Sure.
Now it seems like you're maybe conceding that it's not a lifetime, it's indefinite.
Well, you know, I would
Does
say.
it matter even?
Yeah, I don't think in this case it really matters, because all the court really did was give the open-ended order, articulate that I believe it's a retained jurisdiction, but when you have parties that are this age that have been retired for a while that are not going to have a change in circumstances, in my opinion, because their incomes have been fixed, and they have been fixed for some time, that whether you call it indefinite or lifetime, I think is the same, terminology, and has the same purpose. What's kind of troubling about this case is it really is a short-term marriage, no matter how you look at it. I understand that
12 years of short-term marriage in today's day and age.
it is. I've been married myself 9 years, and I believe that's short-term. And in the research that I've done, there are cases, and I believe it's Wachowski, which is mentioned in my brief.
If you're 75, is that a short-term marriage?
That's going to be the next question.
Yes, I believe it is. I believe that the 12 years of marriage in a vacuum is short-term. And even when you look at the age of the parties, it really is short-term. These parties were married before. I think that should have played into the analysis. But the Wachowski case that I've referenced in my brief, that was 14 years. And I believe that was a 3rd district case. The district there classified it as short-term as well. I don't see long-term marriage being referenced to really anything under 20. That whether it's in legal precedent that I've researched or in cases I've practiced on my own, once you hit that 2-digit, 20 years, the courts are automatically calling that long-term.
Haven't we in our jurisprudence though referred to these type of marriages as medium?
I've not seen that phrase, but if that's what the court is saying, then yeah, I think you've got some different phrases that we're using, short-term now, if we're using medium and long-term. But I think that when you talk about indefinite or lifetime, those have strictly been relegated to the long-term marriages. In this case, going on to the indefinite nature or lifetime, again, we've got 12 years that these parties were married. Both parties, I believe when they got married, were in their mid-60s. At most, if you look at the unwritten rule of thumb, 1 for 3, there should have been 4, maybe 5 or 6 years of support.
But we've actually said those rules of thumb are arbitrary and not enforceable.
Yeah,
Because it's a discretionary call of the court.
absolutely. It is a rule of thumb, which by their nature is just something parties go by to try to resolve cases. And but those cases that I've had to go to trial on and get decisions, courts have never articulated a 1 for 3 rule, per se. But that's kind of how it shakes out, because that's how practitioners have really resolved cases and have tried cases. Switching gears, if I could, for a second, we've got here 2 parties that, again, they're up in years, but we have very limited income. On my client's side, he's got 2 sources. He's got Social Security of $650, and his pension that's been in payout since '94 of $17.66. And I did the math about 5:45 this morning, so it's $2,410. $2,410 a month is all he makes. That's it. His expenses, as articulated, I think, in trial and in the affidavit of income and expenses that he filed with the court, his expenses per month are $2,300. Now, when you take $550 a month off the top, this elderly gentleman is struggling to make his bills. Now, we've got the appellee who's got living expenses. Now, the problem with what we have from the appellee is that the affidavits that she's filing have her monthly expenses at $3,800. And in my brief, I kind of poke some holes into those expenses. But she's also got Social Security, I believe, of $1,540. Now, what the court has done, in essence, is equalize income for a 12-year marriage. So I think that was a little inequitable. The difficulty that we have here is, indeed, we've got parties that are not earning a lot of money and that they're elderly, but again, I go back to the 12-year marriage, and that is not medium or long-term in my opinion. What the trial court didn't do, and I think I set this out in my brief, there were assets generated during the marriage. There were, I think, a vacation home, a marital home, and some other accounts. When I totaled it up with the limited record that I really had available to me, I totaled about $110,000 that the appellee had received as in for property division. Now, I think that the trial court should have looked at that amount as an amount that the appellee could use for her income and for her monthly maintenance and expenses, and bills and expenses, because that is a factor under 3105.18, our assets in retirement. When I read the record and read the transcript, it jumped out at me that luckily these parties had some assets to divide, and they did so. The case of Wachowski versus Wachowski, I think will assist this court a great deal. And when I read it again this morning, this is how the Wachowski court came up with their decision. And this is in 2010 Ohio 1501. Those parties, admittedly, were not in their 70s as these parties are, but there the marriage was 14 years. There the husband was working and earning about $2,100 per month. The wife was not working at all, so we don't have any Social Security that was being obtained. In that case, The support order was $500 a month until retirement. I think when you take those components of Wachowski, we have a 14-year marriage, younger people that are still working, wife, I believe, had the ability to work, and you compare that with what we have here, we've got virtually the same amount of years, we've got incomes that are comparable, and we have a spousal support that's less, $500 a month. But again, we're not talking about receiving Social Security in Wachowski, so that makes it a little different, until retirement. So I think what the trial court really should have done is analyze it more in the term of a short-term marriage, rather than looking strictly at the ages, because you're really putting a great burden on the appellant in this case. The last point that I want to raise.
And you're reaching your 5 minutes right now. Go right ahead.
Okay, I'll say, thank you very much.
Good afternoon. You end your day here in Medina with a domestic case, one of the court's favorite areas as well. I'm Linda Hoffman, and I'm pleased to represent Angeline Noble, formerly known as Mahoney. I tried to follow the argument of appellant here, indicating he had 2 issues on appeal, and I'm not sure we got to the second one. I understand the question is duration, lifetime versus indefinite. And I think the other one was, as articulated in this brief, the actual amount that this court awarded, the trial court awarded. Fortunately, in this case, there's really not a dispute on the facts. That's why the trial was short. The transcript as to the trial issues appealed on spousal support, there really wasn't a lot of contention. It's a 12-year marriage. The parties were in their mid-70s. It was undisputed the amount of husband's pension income and Social Security and wife's Social Security. There's about a $20,000 annual disparity between husband and wife. And the trial court took great pains in its decision to articulate the factors of 3105.18C1, A through all its subdivisions, and articulated what testimony it heard on those issues, whether it concluded that that issue was favorable to an award of spousal support for wife or not. It's a mischaracterization to say that the court strictly looked at the ages of the parties. I think you had a $20,000 income disparity. You had the folks living together as husband and wife for 12 years, and their age is somewhat relevant, not to the length of the marriage, but to the fact that these folks were not going to be generating additional new income. And for that reason, the court said when it looked at factor B, earning abilities of the parties, that wasn't relevant at this point in the case. Likewise, even though the court articulated what the facts were as to education, that also wasn't going to be relevant. It did address their ages and health. The duration of the marriage is 12 years and 4 months. It did address the property division that had taken place. It articulated that husband did receive some premarital property in the division, and that it was required to look at income from all sources, which included income from the property division. And in this case, the 2 income sources for husband were his pension, disability, and Social Security, and the sole income for wife was her Social Security. I think under all the facts here, if what we're looking at is to say, did the court reach an equitable decision? It did. It put both parties in the sunset years of their life in a position to have equal economic opportunities to live that life out as comfortably as they could on the limited income that they had.
Let me ask you, when she submitted her expenses to the court, is that relevant? Is that something the court should take into consideration when assessing spousal support?
The court is entitled under spousal support to look at any relevant factor in addition to those that are articulated. But I think what's interesting in this case to know is trial counsel, for whatever reason, chose not to inquire or make that an issue at trial. The trial brief on appeal indicates that maybe husband is questioning whether wife really had a diagnosis of cancer. If you look at the docket in the trial court, you'll note counsel for husband undertook no pretrial discovery. If you look at the docket, you'll see the notices regarding all discovery were from wife to husband in terms of subpoena of records, interrogatories, and requests for production of documents. At the trial of this matter, wife was never questioned on cross-examination regarding her health, regarding her expenses.
There is some flavor in the trial court's entry that a decision was made that, by the trial court, that after the termination of the marriage and she lost her health insurance, supplemental health insurance, that she would not be able to afford supplemental coverage based on her income. That husband would be able to continue in his health plan because that was part of his prior pension. I guess the question is, I understand what you're saying about not cross-examining her on whether or not what her actual health status was, but is there evidence in the record about what her health insurance supplement would be necessary or need to be paid? Because it kind of sounds like, a little bit from the entry, that the court is already projecting, well, she'll have to pay X number of dollars in supplement for her supplemental health insurance after this marriage terminates. So I'm going to create that as a cost for her when I look at this, whether spousal support is equitable.
I can't address whether that was actually testified to in the record, and it would not have been listed as an expense on my client's affidavit because she had not incurred it at that point. I think it would be reasonable for the court to expect that expenses that were provided as husband's disability retirement benefit were no longer going to be available to her and that she would have a cost for that.
But she didn't put it on her affidavit. See the point?
Correct.
And I'm not saying that it's an abuse of discretion to look at these things. I'm just saying, when you look at what's equitable here, we have this health insurance cost that it appears to me that the court was looking at when it made the award of spousal support.
I think the court did. I think the court looked at that as it looked at all the other factors. It looked at the health. It looked at that neither of these people received income-producing property in the property division. It's nice that they had assets and that they were over $100,000 that they each had, but they were, for husband, a place to live. For wife, it ended up being part of the cash that she received from the sale of their vacation home in Myrtle Beach, some of the retirement assets which she had been living on during the period of this case making its way through the system. So I don't think it was an abuse of discretion for the court to consider that, even in the absence of a specific dollar amount of the testimony. The bottom line was both of these folks were in their sunset years, limited sources of income, and the court's decision put both of them on equal footing moving forward to meet their expenses, whatever they would be, and gave husband the opportunity to come back in by saying there's retained jurisdiction on, I believe the court's actual language in the entry was that the court would look at all factors related to all aspects of the award of spousal support were subject to the continuing jurisdiction of the court. And I'll leave it up to this court's interpretation, but I read all aspects to include amount and duration, and there would be nothing that would prevent husband from coming in, except I think at this point he'd have to argue that there was a change of circumstance that now made the previous award no longer appropriate.
What about these expenses, though, that, I mean, you said the court could look at them, so when she says stuff like $600 a month for vacation, $160 a month for mail care, that seems a little extravagant, doesn't it?
Well, I think the court addressed the standard of living of the parties. They did enjoy a vacation home in Myrtle Beach and make trips there.
You said that the standard of living was not outrageous, that it was moderate or whatever. That's, somebody that spends $600 a month on vacation, that doesn't seem $160 a month on their hair and nails, that seems a little extravagant moderate type of living.
I think you have to look at these parties. He ran a salon, and she worked within the salon, and I think maybe more than the average person, that's where their interests were. So attention to hair and nails might be more than an average couple coming in, but it was
$600
hers.
a month in vacations.
And that would be, if I do my math, $7,200 a year for the trips to Myrtle Beach and the places that they
Which
had
they
enjoyed.
elected to choose, they sold that.
They did elect to sell that shortly before this litigation commenced, they did. But that was something that was enjoyed by them, several trips to Myrtle Beach.
And her original affidavit said $800 a month for clothing. And then she did amend that.
Correct. Correct.
Is there any evidence why it went from $800 to $200 a month?
I think, quite frankly, the economic reality is she was at the point of this litigation, she was residing with one of her 2 adult daughters. She actually had moved between their homes, as she did not end up with a residence as a result of the sale of that property. Husband retained the marital home, and he also retained his premarital second vacation property that was in Chippewa Lake, and that was to be sold, but that has not yet occurred either. So I think if the court takes a look at the factors here, the trial court did its job in considering each of the factors under 3105-18C1. I don't believe the court's decision was an abuse of discretion, either the amount or the duration. Yes.
I just have a question. I
Sure.
think it's a pretty foundational question. I mean, the court made a finding that the remainder of the pension is husband's separate property.
Correct.
And then there's a citation here to Frederick versus Frederick saying that the court found husband's portion of divided marital pension was appropriately considered in the spousal support analysis, even though it meant wife received 1/2 the pension as property division and additional money from husband's share of spousal support. I got that. But those assets, that pension was acquired during that marriage. This husband's pension was acquired prior to the marriage.
That is correct. And I think the trial court also noted that wife number 1 was receiving her share, and this was the residual share that was his. And I believe the court's decision indicates, when she addresses the issue of income from all sources, she says, I'm including in that income from 3105-171, which is the property division.
Okay, but this property had already been divided in the prior divorce. The pension was awarded to him in the prior divorce.
Correct.
It wasn't divided as of this case. This case stated it was separate property that he got somewhere else. So that'd be like saying, husband, you own this Ferrari that's worth $750,000 that you acquired prior to this marriage, but we're gonna order you to sell that Ferrari and pay your spousal support out of that money. Can
And
the
I would
court do that?
Absolutely, because the court can, A, under the specific language, consider income from all sources,
Well,
and
okay,
this
but I'm
court.
talking about, that's not income. If you sell the Ferrari, that's not income. Is that income? That's the proceeds from the sale of a separate property.
Proceeds from the sale of the separate property. In this case, though, the pension was income that was in payout at the time they got married. Marriage number 2, it was already in payout, and trial courts in many cases issue distributive awards from separate property to spouses, to the other spouse. So
A
I think.
distributive award.
Correct.
Okay,
So I think the
okay.
court certainly has the authority under 3105-18C to make that award that it did in this case, and put these folks in a situation where, again, they can live out the remainder of their years both on the same economic footing moving forward to meet whatever their expenses may be. And they probably wouldn't be the first couple not to live within their means, but there's only so much money to go around, and these folks, certainly, they're not, they're both ending up with about somewhere in the high 20s, low 30s. It's not a whole lot of money to live on and meet your expenses as a retiree. But we think the court's decision is supported by ample competent evidence. There was no abuse of discretion. We ask that the trial court's decision in this case be affirmed. Thank you.
You have 5 minutes remaining.
We'll talk, not too fast, but I'll try to get through. I have 3 points that I wanted to hit real fast, and counsel for the appellee used this phrase twice, that the parties were on equal, the trial court put the parties on equal footing, and then she used the phrase, same economic footing. I'm going back to my first point that this was a marriage of 12 years. Putting the parties going through a divorce on the same footing or equal footing, equalized income, simply isn't fair. It just simply isn't fair no matter how old these folks are. If the trial court wanted to give $550 a month for 3 years or 4 years or what have you, that's a horse of a different color. But to do it on an indefinite basis, or lifetime basis, is just simply not fair. I was thinking about this as counsel was talking, that when she indicated that, when counsel indicated that the court retained jurisdiction to look at amount and duration, if a change in circumstances arose, when in the world is a change in circumstance going to arise for these folks? They are, however old they are, they're just going to keep getting older. The amounts of income are never going to change. We've got Social Security on both ends. That amount probably isn't going to fluctuate. Hopefully it'll still be there in 10 years, but that amount is never going to change. And the pension amount that the appellant was receiving in payouts since 1994 hasn't appreciated really hardly at all in the last few years. So one can argue reasonably comfortably the circumstances for this appellant, unfortunately, are never ever going to change. And given his testimony at the trial that he wasn't feeling all that well and has these aches and pains, potentially they may get worse. The last issue that was touched upon by counsel's argument was an issue I was going to bring up to the court at the end of my beginning argument, and that is the cancer diagnosis. I thought long and hard about addressing that in my brief because I did not want to come across as crass or otherwise insensitive, but I took a step back. Personally, I've been through a cancer diagnosis with my wife about 4 years ago, and I went through that process. And my goal in bringing it up in this case is that when you have a divorce trial, you go through everything, expenses, A to Z, whether it is medical expenses, healthcare expenses, automobile expenses, gasoline, you name it. The gamut has to be run to give the trial court every single expense that the parties can to determine whether or not, or what a reasonable award is. And the record down below, unfortunately, is kind of devoid of a lot of the necessities that one would typically provide to a trial court. And so my point in bringing up the cancer diagnosis is that we didn't hear anything about any kind of medical expenses or how it physically affected the athlete to empower the trial court to give an indefinite support order or to justify $550 a month out of $2,300 a month total that the appellant had to spend per month. So that was an analysis that I went through after looking at the record. Again, I believe that the trial court erred in giving this indefinite spousal support, given the duration of the marriage. The trial court erred in the amount that it ordered, being $550 a month, given the lack of income, and the fact that the lion's share of the income was generated with a premarital pension payout. And again, I want to thank your court for the time this morning and your patience, and thanks for having me today. I would ask that the trial court's order be reversed. Thank you.
Thank you both very much for your presentation this morning and I guess this afternoon. Court will take the matter under advisement. We will issue a written decision which will be mailed to both sides as well as posted on our website.
Thank you.
Thank you, Your Honor.
We are adjourned until Thursday.